right arm's length bodies where necessary, but that we also have appropriate responsibilities and accountability to your Lordship's House.
Fourth oral question, Baroness Levitt.
My Lords, I beg leave to ask the question standing in my name on the order paper.
My Lords, the Government did not receive advance sight or notice of this interim update from the EHRC. The Government had requested a meeting with the Chair to discuss their approach to developing an updated statutory code of practice, which will reflect the implications of the ruling and support service providers, and this meeting will take place soon. The EHRC will consult with relevant parties on its revised code, and we expect them to do this widely and broadly, listening to diverse voices. We will then consider the EHRC's updated draft code once they have submitted it.
My Lords, I thank my noble friend, the Minister, for her answer. I speak today primarily as a lawyer, but also as the parent of a trans child, in the belief that these matters should and can be discussed in a non-partisan way with respect and care for the rights of all those involved. Does my noble friend agree that it would be wise of the EHRC to consult the Attorney-General about their intended revised legal guidance, given that the update issued last Friday evening contained legal inaccuracies which have caused consternation to real people living real lives?
The approach that my noble friend set out is precisely that I outlined last week in responding to the statement. The Government has set out our expectation that service providers follow the clarity that the ruling provides. The EHRC's interim update provides a perspective on how the Judgment and Equality Act are practically applied in some areas. It's a snapshot reflection rather than full guidance. The EHRC has announced that they will be updating their code of practice and has committed to seeking views from affected stakeholders, and I'm sure that they will consult widely on this. I would add that the application of the Supreme Court ruling to different services and settings is complex. It requires careful work to ensure that we provide clarity for a wide range of varied service providers of different kinds and sizes, so that they have confidence in how they apply the Equality Act on a day-to-day basis.
My Lords, I declare an interest as Chair of the EHRC, and I hope that I might be able to illuminate to the House what happened and appreciate the Minister's response just now. Would she agree with Section 2.2 of the framework document that we have with Government, that EHRC does not perform its functions on behalf of Government and is to operate independently of Government? Moreover, she has to ensure that the Commission is under as few constraints as reasonably possible in determining its activities, timetables and priorities. Now, having listened to her response, I know that she'll agree with me that our priority is to explain the law to the public, which we have done so in this interim statement, and to undertake a consultation on the practical implications of the judgment, and we'll be seeking views from as many affected stakeholders as we possibly can. This is profoundly important for the trans community, and it is right that we published a brief statement of the law and will be consulting with them extensively as we go forward.
The noble lady is right that the EHRC is the Government's independent regulator of equality, of the Equality Act in this case. I welcome her commitment to both producing the statutory code of practice and to the consultation that she's alluded to.
The advance of equality for lesbian and gay people over the course of the last half-century has largely become settled because it was achieved without diminishing the rights of others. But in seeking protections for transgender people, there is often a perceived or actual clash with the rights of others, namely women, and therein lies the difficulties which we are discussing. In helping us to navigate these issues, would there be merit in an overall independent review of these matters, as I proposed 3 years ago? Because at the moment we have a piecemeal approach with the Supreme Court decision, EHRC rulings, the CAS review, other governmental decisions. And in all of this, a culture war being fought which is immensely damaging to the individuals concerned. Is it not time to look at these issues dispassionately, carefully, to detoxify the debate and put the interests of all of those concerned on the right footing?
Well, I think the Supreme Court did look at the issues dispassionately, but the point is that there is now the requirement to consider the implications of the judgment, to do that in a way that provides assurance to service providers and others. That's the role of the Code of Practice and the EHRC in the way in which I've just outlined. Where I agree with the noble lord, and let us be clear that the Supreme Court was clear about this as well, is that this isn't about winners and losers. It's about ensuring that there is both clarity in the law and broad respect for the rights of all people in this country. And as the Supreme Court made clear, there is nothing in this ruling which undermines the protections for trans people put into Labour's Equality Act in 2010.
The Supreme Court judgment, but the need for the interim statement illustrates to me the extent of the anxiety, confusion and disruption surrounding how the ruling will be interpreted. And whilst the guidance is only interim, it shows that there are still a lot of unanswered questions about how this is going to work in practice. So will the government please take a lead, calm the situation and begin to work cross-party to find a way forward which allows everyone to feel safe and protected by the Equality Act?
Yeah. Well, I hope that in the government's response we have been calm. I think we've been clear, but I think we've been calm, and I think we've been committed to ensuring that all groups feel supported by the actions that we take as a government. The responsibility for laying down the Code of Practice does rest with the EHRC, and I'm sure that they will have heard the noble lady's call, and as we've already heard, are committed to making sure that that code is developed on the basis of wide consultation.
My Lords, may I first of all endorse the comments of my noble friend. My Lords, before statutory guidance is issued, how will the government meet their legal obligations across all public services in compliance with the judgment?
Well, there are already, in terms of the clarity of the judgment, as we discussed last week in response to the statement, there is already work going on across, for example, the health service and other parts of government service. But as with others, I think the important clarity around some of the complexities in the application of this judgment will be provided through the statutory code that the EHRC are producing, and I look forward to that.
My Lords, notwithstanding what the Chair of the EHRC has just said to the House, it is quite clear from businesses, the hospitality industry and actually today the Football Association that their interim guidance has created huge confusion. So I'd like the noble Lord, my noble friend the Minister, to confirm for the House that the EHRC interim update is just an update. It is not legally binding, and can that be made clear, please, by the EHRC?
I think I have been clear to this House, both today and last week, that the statutory code of practice that the EHRC is responsible for producing will be the legal basis on which there will be interpretation of the judgment. And I welcome the noble lady, the chair of the EHRC's commitment to ensuring that that is something on which there is wide consultation.
The EHRC has come under the most extraordinary and ill-informed abuse, as has its chair, personally. What more does the government believe it can do to ensure that the independence and functions of the EHRC are properly understood?
Well, I hope I've demonstrated today that the government does properly understand those. And as I said last week, with all of this debate, I do think it's important that it's carried out in a spirit of understanding of the complexities of the application of some of these provisions, recognition that all groups need to be able to access services, but with the clarity in terms of the areas covered by the Supreme Court judgment that I think are to be welcomed.
My Lords, that concludes oral questions for today. We'll have a short pause to allow any members who wish to leave just now to do so expeditiously.